Thank you. Please be seated. Good morning. We're here on CACV 18-0040, Fidelity versus Osborn. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your clients at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. We do have a cross appeal, and counsel for appellee may reserve a portion of the time for rebuttal to address only the cross appeal issues if desired. Also, we have read the briefs and have discussed the case in conference. Counsel, you may proceed.
Thank you, Your Honors. Charlie Callahan on behalf of Fidelity National Title Insurance Company, and with me is co-counsel David Satnick. I will be addressing the Morris issues and the...
Let me stop you for just a second. Since you've mentioned Mr. Satnick.
Yes.
It is, we have granted the motion to associate counsel for Hawk Beach, and you probably would have liked to have known that a lot earlier, but for what it's worth, it's granted. Proceed.
Yeah, we were followed up. Thank you. So I will be addressing the Morris issues and the conveyance clause issues, and Mr. Satnick is going to be addressing the exclusion 3A issue, unless we're going to use 12 minutes at the beginning and then 8 minutes for reply and response to the cross appeal, unless the court has a preference for hearing one issue first.
No, we don't.
Well, then I shall begin. And the issue here is Morris doesn't apply to title insurance because the fundamental justification for Morris for decades has been the sharp thrust of personal liability for a third-party liability claim. And that just doesn't exist in title insurance. Morris was a creature of judicial policy.
Why does it have to be a third party, though? Why, if there's a potential loss, isn't insurance is insurance? I'm insuring against a loss, whether it's third party or first party insurance.
Well, and there's a couple of reasons, Your Honor, and that goes to the distinction between title insurance and third-party liability insurance. In a third-party liability situation, the loss has happened. You have a car accident, you have a construction defect, you have a fire. The loss has occurred. You know what you're dealing with, sort of. Although in third-party liability situations, you have emotional distress, you have pain and suffering, you have punitive damages, that the exposure is so much almost infinite and semi-boundless, subject to judicial review, of course, but it's semi-boundless. And so the thought of being able to protect the insured's personal assets, and that's another key distinction.
But isn't it just exposure beyond policy limits that we're concerned about? When this potentially limitless exposure, but don't you have that even in the title insurance context, where you could be, and in this case, if attorney's fees could result in a judgment higher than the policy limits, isn't there the potential for some personal liability in title insurance instance?
And I disagree, Your Honor, and here's why. Because in the title insurance context, especially here where you file the mechanic's lien claim, it's just a claim. You don't have a loss. You don't have a loss until there has been a determination by a court, because title is a legal concept. Title's not tangible like a car or a bone or a piece of property. It's a legal concept, and you don't have a loss against that title until there has been a legal determination.
But once that legal determination is made, then what's the difference? Isn't there a liability?
Right, but the problem here is in Morris is that you're allowing the insured to establish that loss by settling and stipulating against the consent of the insurance company and without a final determination by a court. You're allowing the insured to establish the loss when the policy, the central aspect of a title insurance policy is a determination of title by a court, a judicial determination
But there's a
of title.
protection of it has to be reasonable. They can't just make any kind of settlement that they want. We have that requirement as part of Morris that, and here the parties have agreed, your client has agreed that it was a reasonable settlement.
Right, but reasonable settlement, all you're doing, you're still allowing the insured to establish the loss. Because the reasonableness determination, they're very clear, you're not able to relitigate the merits of the case. You're not able to get the judicial determination of a loss that is required under the policy. There's still that limitation. So all you're getting is just, is it reasonable? But you're still allowing the insured
But don't
to
you still
establish
have,
the loss.
the insurance company can still go in and say there's no coverage.
Right, but that's the difference between the liability and coverage, establishing the loss. And that is, when you have,
Yes, and I apologize for interrupting. I guess I'm understanding that the reasonableness takes into account the point that you're making, that it wouldn't be a reasonable settlement if there wasn't a valid claim. Am I missing something there?
yes, because you're not allowed to relitigate the merits. You're able to consider merits, but there is no judicial determination. There is, and that's the critical aspect of the policy. There is no judicial determination. And the other aspect is there is no personal liability, because you're talking about if there is an adverse determination on title, is the insured coming out of pocket? Does Mortgages Limited have to come out of pocket and say, okay, you've got a valid lien claim?
But it sustains a loss nonetheless, doesn't it? It comes out of pocket because the value of the investment is lost.
And that goes back to what Judge Catani addressed in the Fidelity versus Centerpoint case. And that is, there's a difference between personal liability and financial or economic risk. At page 32, or paragraph 32 of the Fidelity Centerpoint opinion, Judge Catani wrote, CMLC and Mortgages Limited investors argue that although the lien claimant settled the claims in their entirety, Mortgages Limited investors still face greater economic risk. But this argument conflates Morris's discussion of personal liability with overall economic or financial risk, which here included ML investors' potential loss of their investment due to foreclosure. Loss of investment is not an insurable risk, and that's not an out-of-pocket. If the mechanic lien claims gets to be enforced against the property, then they have less of a return on investment. But if the mechanic lien claims get enforced against the property, Mortgages Limited doesn't have to go into his pocket and pay for that. It's only enforceable against the property. It's not enforceable against Mortgages Limited. And the same is true for attorney's fees, because the attorney's fees claim there's only personal liability. The Kiefer case says that you only have a personal judgment in a lien foreclosure claim if there is a direct contractual relationship between the mechanic lien claimant and the other party. Here you have Mortgages Limited, Osborn, then Summit. So there is no direct contractual relationship between the mechanic lien claimants and Mortgages Limited. So Mortgages Limited is never going to be personally liable and never would be personally liable for attorney's fees. So there is no personal liability. There's just potential less recovery of return on investment, which is an economic financial risk that was addressed in Centerpoint, and that's not an insurable risk. And I'm going well into my co-counsel's time, so let me just raise one point with respect to the reservation of rights issue. The trial court said, and the Mortgages Limited successors argue here, that once the reservation of rights is issued, that kind of all bets are off. That's a way too expansive reading of Morris. what Morris says is that it potentially excuses compliance with the cooperation clause. In Parking Concepts, at paragraph 25, the Supreme Court said, Morris thus affects the contract of insurance in but one way. It holds that when the insurer defends under reservation of rights, the cooperation clause may not be invoked to prevent the insured from entering into a settlement without the insurer's consent. However, Morris neither imposes new contractual duties on the insurer nor otherwise expands the rights of the insured. And that's critical because here, the reservation of rights, all that does is says, okay, yeah, maybe you can go settle without violating the cooperation clause, but if you're going to get reimbursement, and Judge Catani, you also addressed this in paragraph 30 of the Centerpoint opinion, your option is to pursue the insurance company on the contract. And if you're going to do that, you have to prove one of two things. You either have to prove prior breach, that's what Morris says. You have to prove prior breach by the insurance company, which hasn't been proven or even argued here, or you would have to prove under the final determination clause, you would have to prove the validity of the liens. Because the final determination clause is still applicable based on what Parking Concept says. You excuse maybe the cooperation clause, but you don't obviate the final determination clause. So that's how they have two ways, prior breach or prove the mechanic lien claimants. And they didn't do either here. And I'll leave the rest of my time.
Good morning, Your Honors. David Satnick, Loeb & Loeb LLP, on behalf of Fidelity, the insurer. We are here today because the trial court failed to follow controlling Supreme Court authority in Arizona, as articulated by the Supreme Court in the Action Acquisition case. As noted by that court, a title policy does not insure against the intentional acts of the policyholder or the insured. And that is the very reason for exclusion 3A in the policy.
Has there been a showing here that it's intentional acts by the lender? You're talking about mortgages limited.
That's correct.
Intentional acts. What if has there been a determination that it was mortgages limited actions that resulted in the liens not being paid as opposed to some malfeasance by the borrower?
Well, there could be no malfeasance by the borrower because none of the funds ever passed through the borrower's hands. All of the funds were placed into a construction impound account and paid directly to the contractor, Summit. The borrower never touched the funds, so there was never an occasion for the borrower to either misuse the funds. One of the arguments that
wasn't the borrower authorized to do? I've forgotten what was done with $400,000 of the funds that were used for a different purpose.
Yes,
I thought the court had said that was okay.
Well, what the court said is that the lender and the borrower could agree that $415,000 of the funds that were allocated specifically for construction could be used for purposes of debt service. That's the diversion of the monies. That money should have gone to the contractors. And while the court said that that may have been within the contractual rights of the lender to reach an agreement with the borrower, they must accept the consequences of that diversion. And the consequence of that diversion is the contractor goes unpaid and the mechanic's lien is created thereby. And it falls into the same category of the failure to fund the full amount of the loan commitment for work that has already been completed on the job.
And what's your response to their argument that that gets you to $1.1 million that Mortgages Limited didn't fund, but here the potential liens were in excess of $3 million? So
Well,
how are we going to settle? Mortgages Limited is responsible for all of that?
The answer to it is very simple. You have 1.1 of a failure to fund. They don't dispute that they failed to fund 1.1 million. They don't dispute that they diverted 415,000. So that's approximately, round numbers, $1.5 million. If you look at Summit's lien that's filed, and Summit was, don't forget, was a general contractor, so all the other subs are subsumed within the general contractor's claim. If you look at their lien, they filed a lien for $2 million, and that's shown at Trial Exhibit 5. Of that $2 million, they showed in paragraph 2, $869,000 for extra work orders. But that was an inflation of the amount that was actually due in respect of extra work orders. And if you look at Trial Exhibit 61, and that's at 6465, you'll see on the pay applications, there is a entry, net changes by change order. It's $419,825. So if you deduct the overstatement by the Summit, the GC, by the 400,000, you get precisely the amount that had been failed, they failed to fund, and that had been diverted to pay debt service. So the lien, the mechanics lien, was never more than $1.5 million plus interest and attorney's fees concededly. But all of the other liens were subsumed within that lien. So these liens were caused directly by the failure to fund, the amount that had been committed, the failure to disperse committed funds for work that had actually been performed. 100% of the work had been performed on this job. And their diversion of the monies. Now, the judge excused that by saying, well, they were acting within their contractual rights. But as the BB syndication case makes clear, a lender can be within its contractual rights, but that is irrelevant to the question of whether it can then foist the liability for the failure to fund or diversion of construction funds on the title company. Those are two different questions. And in B&B syndicate makes clear that even if the lender has the contractual right to withhold funding by reason of the borrower's default, with respect to work that's already been completed and monies that already been committed, it cannot look to the title company to be made whole in that circumstance. So it has to accept the consequences of its own intentional acts. And that's what action acquisition, the Supreme Court said, that it is the intentional acts that 3A addresses, the act that creates the defect, not the intent to create the defect. And it rejected the notion that the insured has to engage in some sort of inequitable or wrongful conduct, such as breaching the contract with the borrower, which in this case we believe the borrower didn't breach the contract at the time that Mortgages Limited withheld the funds and failed to fund. If you look at the documents, and specifically Trial Exhibit 61, and you'll see that 100% of the work had been completed. The only monies that were due was retainage, and they never paid a penny of that retainage. But the work was certified as completed. They got the benefit of that work. It improved the value of their collateral, and it is under the authority of the Acton acquisition case, the B&B syndication case, Bankers Trust case, the Brown case, to enable them to then recover under the title policy would create an undeserved windfall. And I would respectfully submit that the court erred in ruling that these claims here were not excluded under exclusion 3A of the policy. Any other questions? Thank you, Your Honors.
Thank you and good morning. Richard Lorenzen for the insured defendants. Any argument that Morris doesn't apply to title insurance is contrary to first principles of that case. Morris isn't limited to a specific line of insurance or a specific type of economic risk. That's not what the case says, and that's not what it was about. What it was about is that a cooperation clause, like the one in this case, that gives an insurance company control or the right to control defense and settlement of third-party claims against its insureds, which is what was happening here.
Counsel, let me ask, wouldn't allowing the insured to not fully fund its loan and then receive payment from the insurer for the work that Summit completed, wouldn't that result in a windfall to your client?
No. In this particular case, if you want to talk about exclusion 3A first before Morris, I'm happy to do that. This court doesn't need to decide, for purposes of Arizona law, whether exclusion A applies or the extent to which it applies where a lender has failed to fully fund the loan, for three reasons. First, Fidelity failed to carry its burden of proving as a matter of fact that the failure to fund $1.1 million could lead to $3 million or more in mechanic liens under any theory. And as to that,
Why wouldn't it necessarily apply to at least 1.1 million of them?
well, if it did apply to that, then there would still be 1.9 million, and the settlement was for 1.7 million. And I will note, Your Honor, that at one point, Fidelity, and this isn't briefed because it wasn't raised by them, they want the whole enchilada, so to speak. It's up or down. In the trial court, they filed a motion for summary judgment at one point saying we should be entitled to a credit against the liens. We responded to that by saying, even if that's the case, under Morris, you're bound by the fact and amount of the settlement. Under a related case, Brown, I forget the entire name of the case, damage issues are to be determined in the reasonableness phase of the case. And since you've agreed that the settlement amount is reasonable, you're bound by that unless you can prove a coverage defense as to the whole amount. And they never replied to that. So that became sort of a moot issue. Instead, they filed a cross motion for summary judgment in response to our motion on exclusion 3A and said, we're completely off the hook. And that's how the litigation proceeded. But the answer would be, even if they were entitled to a credit, that would go to the reasonableness of the settlement. And they stipulated that the settlement was reasonable. As to the exclusion, if that answers your question.
Seems like the reasonableness of the settlement is as between Mortgages Limited and the lien holders. I'm not sure that answers the question of why Mortgages Limited would be entitled to additional funds when it didn't. Going to Judge Cruz's question, if Mortgages Limited didn't pay the 1.1 million it should have paid, why should it recover that from the title company?
Well, the answer would be, and again, I'll get back to the point that I don't think you need to get to the legal issues because they failed to prove as a matter of fact that the 1.1 could cause 3 million in liens, but implicit in your question
You could clearly cause 1.1 million in liens.
Well, not clearly. Implicit in your question was that they were required to fund the 1.1. The trial court determined that that was not the case. The trial court ruled that because of the borrower's default, Mortgages Limited was not required to fund the 1.1. So the question would become for the court, if you wanted to reach that, is whether a breach by the lender in this context is or is not required in order for exclusion 3A to be applicable. And I also want to note in your question that it wasn't, the settlement was not with Mortgages Limited. The settlement was between my clients, who are successor owners of the debt, and the mechanic lien holders. And so to take your question maybe to just a purely logical or practical level, if there were $3 million in liens, and if 1.1 million was required to be paid, and if it had been showed that if it had been paid, the money would have been used to pay the contractors, then Fidelity would have been looking at 1.9 million in covered mechanic lien claims.
I understood counsel to be saying if that 1.1 million had been paid, the liens would have been satisfied, and the rest of it is something that's accrued as a result of not having paid the 1.1 million, or are you suggesting that's not part of the record?
I did hear him say that, and that's his testimony. I want to remind the court that Fidelity didn't call any witness at trial. There was no live witness to explain these documents. Mr. Satnick is standing here telling you, well, you do the math, because I'm telling you, Mr. Satnick says, this document's right and that one's wrong. And if you agree with what I, Mr. Satnick, am testifying to, then I can move the numbers around and reach the conclusion that I want you to reach.
Well, it's not really testimony. I mean, he referred to exhibits that had been admitted. So he's saying this is the conclusion I'm drawing from those exhibits. And we have to look at those exhibits as well.
Yes.
To reach our conclusion.
Yes, Your Honor.
And you have a different interpretation of those exhibits.
My interpretation is what Summit said. Summit filed a lien, and it said, here's the amount we're owed. My interpretation is that Summit never said that our lien claim subsumes all of these other claims, mechanic lien claims. What Summit said in its lien foreclosure complaint is it sued all of the other mechanic lien holders, and it asked for judgment, declaring that its lien was superior to or on equal footing with those liens. It did not say, we're bringing this action collectively on behalf of all the lien claimants against the owners of the property or anybody else. Summit sued those people. And then the bankruptcy court was presented with this motion to sell the property, and Summit objected. And the net result after notice and a hearing is that the bankruptcy court determined that there was $3.5 million that was necessary to cover the liens. And what the record also shows you is that in the trial court, what Fidelity represented in its statement of facts relating to the exclusion 3A motion for summary judgment was that the total original amount of the lien claims was approximately $3 million. They referred specifically to the Summit lien foreclosure complaint, and they said the Summit lien is $2 million, and then the complaint lists in paragraphs that are specifically adopted and referenced in Fidelity's statement of facts another $922,000 of mechanic liens. So the record shows that Fidelity contended below that the liens were $3 million. I want to emphasize again, my clients have no personal knowledge of any of this. These are people who invested, they purchased the debt, and as to what Mortgages Limited was doing or not doing, we have no personal knowledge. So we do have to look at the exhibits, and we do have to look at the record. And in this particular case, I'll also point out that Fidelity's position below was that the amount that was not funded was $1.1 million. They took that position, for example, during closing arguments. Fidelity told the court, the documents and evidence show that after the payment was made, the last payment to pay draw request number 39 in full, there was approximately $1.1 million left to fund on the construction loan, Your Honor. And yet they file a reply that says there was another $1.4 million. It wasn't mentioned here today, but that's There's no exhibit that says that. And then they said, when you take a look at the second page of Exhibit 37, you see that after all the various advances have been made on account of the approved construction budget, that leaves approximately $1.1 million remaining to be funded under the loan. That is as of April 2008. Took the same position in its disclosure statement, statement of facts, motion for partial summary judgment, and I could go on and on. And that's the interest, the $400,000 in interest that they want to add on to it was funded. The difference there is that the borrower asked for ability to use that to pay 1 month's interest, and Mortgages Limited agreed. Well, BB syndication, which is their primary case, makes it clear that that's a problem in the payment process. And BB syndication makes it clear that if a sophisticated title insurance company wants to protect itself from funded money being used inappropriately, it gets a disbursement agreement. And BB syndication says if it doesn't get a disbursement agreement and money is used for an improper or a different purpose, or a purpose that the insurance company wouldn't have approved of, it's covered. And when Mr. Satnick, again, is telling you no money went through the hands of the borrower, there's no evidence of that, period. There's no evidence as to to whom the money was distributed or what that person did with it. The only thing they have is an interpretation, as you point out, Your Honor, that the loan agreement gave Mortgages Limited certain rights, but that doesn't prove that they exercised those rights. There's no evidence that, he says the contractor got the money. Fine, what did the contractor do with the money? There's no evidence. Anyway, I've wandered a bit, maybe from doing the math, but that's very important to us because as a matter, the trial court made a specific finding of fact that the amount that wasn't funded is $1.1 million. The trial court made a specific finding of fact that Fidelity failed to carry its burden of proving, as a matter of fact, that Exclusion 3A applies here. So in order to overcome those specific findings, Fidelity would have to convince you that they were clearly erroneous. And Mr. Satnick's interpretation of exhibits doesn't satisfy that test. I do want to shift back because, and I appreciate that, before I do that, there's another reason that you don't need to get to the legal nuances of Exclusion 3A. There's two more reasons. One is that, as I was saying before, there's no proof that these liens were not the result of the use of money for purposes other than paying construction costs. None. And then third, as a legal matter, Fidelity failed to prove that it can raise an Exclusion 3A defense based on what Mortgages Limited did against my clients. My clients are innocent co-insurers. Arizona recognizes the innocent co-insured doctrine. The title insurance policy, here's a case where I think the exception proves the rule. The title insurance contract has a limited exception to the innocent co-insured doctrine. It says, we, Fidelity, are reserving defenses against Mortgages Limited as to people who did not pay value for their interests in the debt and or acquired the interest in the debt with notice of the defect. So if my clients are necessarily tagged with defenses against Mortgages Limited, there would be no reason for that exception. And they failed to prove that the exception applies. But what I do want to point out is that what Morris was about is a cooperation clause. And the fact that under a cooperation clause, like the one in this case, that gives an insurance company the benefit of controlling third-party claims, defense and settlement of third-party claims, that cooperation clause isn't a one-way street that operates solely for the benefit of the insurance company. Instead, what Morris said is that in order for the insurance company to have the benefit of controlling defense and settlement of the claims, it is required to accept the burden of unconditionally assuming liability for those claims. In other words, if they want to fight the third-party claims and they want to control that fight, they have to put their money where their mouth is. And that's why the court specifically held that a cooperation clause, like the one in this case, quote, forbids an insured from settling only claims for which the insurer unconditionally assumes liability under the policy, period. Only claims for which they assume unconditional liability under the policy. They did not in this case. They said we reserve our right to deny liability for the claims. And according to Morris, that reservation of rights transferred control over settlement and defense to my clients because it exposed them to economic peril and the danger not only of a judgment in excess of policy limits, but the court says repeatedly, or a judgment that may not be covered. And specifically in this case, Fidelity's reservation of rights exposed my clients to the danger of a judgment that might not be covered for over $3.5 million, plus attorney's fees. The case that Mr. Callahan refers to doesn't say there's no personal liability for attorney's fees. It talks about whether a property owner is subject to a lien, a mechanic lien in the first place. That case doesn't address the attorney fee statute or that aspect of personal liability. As we pointed out in our papers, there's also a risk of personal liability for trespass damages. They have no response to that, except to say, well, that's not this case. But in any event, Morris says danger of a judgment in excess of policy limits or one that might not be covered. And so, as in Morris, the insured defendants were only able to avoid such a catastrophic outcome by negotiating a reasonable settlement that was in their best interests. The settlement benefited Fidelity because it reduced its exposure under the policy while preserving its ability to challenge the reasonableness of the settlement and contest coverage. It's not a windfall because in this case, over $40 million went out from the investors to the borrower. They were only able to sell the property for $19 million. They paid another $1.75 million, which is more than Mortgages Limited didn't fund. So they're in the red on that. To the contrary, Fidelity was benefited because the settlement reduced its liability and exposure on the policy, and as Your Honors pointed out, preserved their ability to challenge coverage and challenge the reasonableness of the settlement. Unless there are further questions, that's all I have.
Thank you, counsel.
Thank you very much.
I will speak first, and since Your Honor seems to be focusing on the 3A issue, Mr. Lorenzen is correct. You don't need to take my word for it because we have the documentary evidence. And unlike the frailties of the human memory, the documentary evidence does not lie. If you look at trial exhibit 31, you will see that the funds are being dispersed directly to and a check payable to Summit Builders by Mortgages Limited. At no time were any of the construction funds, and all of these are in evidence, all of these draw requests are in evidence. At no time were the funds released to the borrower. They were paid directly to Summit as the general contractor, who in turn paid all of the subcontractors. If you go back to the request exhibit 61, you will see that there is a certification by the architect that the work is 100% completed. There is a request for $808,000 for partial release of retainage, leaving a balance of $610,000. Easy math, that's 1.4 and change million dollars. Precisely the amount that was underfunded and diverted. And those two numbers, had they been paid by Mortgages Limited would have paid Summit and all of the subcontractors for all the work that was performed in connection with this project.
Thank you, counsel.
I did have 1.5 minutes.
You do,
May I?
yes, to address issues on cross appeal.
Yeah.
Yes.
Or may I?
I'm sorry.
Am I also allowed to?
Let me give you your 1 minute and 28 seconds to respond.
Thank you, Your Honor. In the record, there are only 4 draw requests. According to Exhibit 61, that was number 42 draw request. So 38 of them aren't even in the record. The only evidence of the draw request is assuming it at face value, what was being asked for. It doesn't show what was done. And Exhibit 61 also has a notation that says denied due to lack of backup. So my interpretation of that is that it was denied due to lack of backup. There's no testimony that says that's not true. Thank you.
Thank you. Counsel, we thank you for your arguments. This matter is now under advisement. We will issue a written order in due course, and all other matters heard today are also under advisement at this time. We're at recess.